Welcome to the Fractured Families podcast. I'm Charity, your dedicated parental alienation coach, here to guide and support families as they navigate the challenges of high conflict divorces and custody battles. On this podcast, we'll share insights, practical strategies, and hope for those on the journey toward healing and justice. Whether you're personally experiencing these challenges or just want to learn more about the complexities of parental alienation and custody disputes, you're in the right place. You are not alone. This is the Fractured Families podcast, where every voice matters and every story is heard. And if you find my conversation helpful, don't forget to like, subscribe, and share. Your support helps us reach more families who need it. Hi, thanks for joining the Fractured Families podcast. I'm Charity, your host. I have with me today Shawn Philbert, who is a lawyer out of Ontario, Canada. I met him at the PASG this year, and he was gracious enough to be a guest on the Fractured Families podcast. He's going to talk to us about his practice, how he fell into parental alienation, some successes, and some tips for those that are looking for support from a legal perspective. Shawn, thank you. Why don't you just tell us a little bit about you and your practice and how you got to this place?
Okay. Thanks for, again, allowing me the opportunity. My practice started actually in my parents' basement. I started as a sole proprietor, and I had no funds. So my dad and my mom said, "Hey, you can have a law office in our basement." And I said, "Sure." So I started there. And the problem I face is that my parents would argue a lot, and I would have my clients in the basement listening to my mom yell at my father for leaving the fridge open. So I decided that I was going to change my office location, and I actually started to take on a staff, and my staff is very multicultural. I have every kind of nation that's worked here. I feel that it's a great opportunity to give individuals from other cultures to work together, and we have quite a United Nations worth of staff here, which I'm very proud of, and we all come with our own skills and backgrounds, and I think that is fundamental to helping clients, because all our clients are from different cultures, different backgrounds, and we can, we have circle time, we discuss them, we understand them, and we help them. So I actually started as a universal lawyer, all types of law, criminal, immigration, everything, and family just kept coming back to me, and more family files were coming my way. And I decided that I was going to, it was only recently, well, I have always done family, but I really started focusing on the high conflict family matters. And I noticed that there was always a theme of parents accusing the other parent of preventing access or parenting time with the other parent. So I actually represent both sides. I represent the individual who's accusing the other parent, or I would say the favored parent, and then the targeted parent. I represent both. I think it's important that you have a lawyer that knows both sides, because sometimes your own client may not see their weaknesses, and and it's not on purpose. It might be subconscious. And as a lawyer, I think it's our responsibility to assist the child or the children involved, and that will by default assist the parents. So if I can't go blindly, I think it's a disservice to the client to go blindly into a litigation just based on their allegations. Either one. I test them. I sit down with them. I actually try to figure out what's the best way we can resolve them. Unfortunately, sometimes we have to go to trial. Sometimes we have to go to court, and we're prepared, because when we go to court, because we've acknowledged our own issues, we're stronger and more credible in front of a judge. And I think that's very, very important. So in a long start, I started from my parents' basement. Now I'm on top. I have my firm. I'm on the third floor. So so, we got 3 more floors to go in my building, but I'm enjoying it. And I think it's essential that you connect with your clients, especially when you're dealing with an alienating a subject. So I can tell you, I've had um, actually this morning I had an interesting call where you have the favored parent feeling frustrated because they feel that when they go to court, they have all these allegations that haven't been proven, all these terrible things, and the client actually told me, he said, well, the reason why the child doesn't want to go to see the father is the father has been abusive, the father has been mean, father has been planting seeds or trying to involve the child in the parent conflict, and the child is 11 and doesn't want a part of it. So the child's saying, I don't want to see dad. And the mother is frustrated because there you just she just gets labeled as being an alienating parent. And so you see it could go both ways. And then there are many times where right now I'm in the court of appeal case, a very interesting case where a parent had actually been removed from the child for quite a bit of time, over 8 months, a blackout period, and admitted that the reason why is because of her own alienating behavior. Therapist put the child back in, and now the child hasn't seen the father for a year. And when I said to the court, we have to get the child back to the father, such a long, drawn out process. And when the alienating parent wanted something, she wanted something from my client, she just went to court and requested it. And I'm like, no, 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 no. Like, you can't do that. You can't just make up the rules when you want it to do it. And that parent was actually successful. And I am now appealing the decision. And that's very important because we have to hold parents to accountable to the agreements that they've done and to the court orders. A lot of the time in the alienated parent cases, one parent is not following, they're doing self-help, and it's to the detriment of the child. And if the courts don't follow up, if the courts don't enforce that, then the child suffers and the parents suffer because they spend so much money fighting, not emotionally, but also financially. And one of the focuses that I have is holding the court accountable for those orders, because it's not the parents. It's easy just to point their finger and see no parents is or no parents is flawless. But what happens is that the court has to protect the child by following the order, and I would say they're not doing a good job at that right now. Um, I can just keep talking unless you have anything specific.
Yeah, so I was just curious, when you have I love that you support both sides because I mean, we all know that parental alienation is super counterintuitive. And how do you determine like what tactics or strategies do you use in determining if a parent comes in and says, I'm being alienated, and oftentimes they could be the alienator. How are you determining that? Do you have any strategies?
Yeah, I think the most important thing, because I can tell you stories from both sides. I had a file where the mother was protesting that the young daughter could not go see her father. There was no possibility the daughter could see the father, and the daughter was afraid. There was lots of evidence of this daughter being afraid. But then when I sat down with mother and I started asking her questions, because remember, I know both sides, I start saying, well, when did your daughter start becoming afraid of her father? And it just
Mhm.
happened to be around when mother and father had the conflict. Prior to that, there was no issue. The daughter was spending half the time, 1 week on, week off with dad, loving it. But then mother and father had a fight, and then all of a sudden the daughter didn't want to go. So then one of the other issues is the mother said that father was showing the daughter inappropriate pictures. And I said, well, can you show me these pictures? And it was anime. And I said, well, I don't see this as pornography as you have stated. So what else do you have? Well, they said, you know what? Father is not messaging the child appropriate messages. And I said, well, show me the messages. And the messages were totally fine. Right. So now I'm challenging the mother. And I can tell you, I have many cases where I challenge the parent and then they decide they don't want me as a lawyer. Right. So the reality is I prefer that. I prefer that because at the end of the day, those same individuals continue on for decades, and they spend hundreds of thousands of dollars, and then they end up representing themselves. And then they will come back to me and say, you know what? I should have listened to you. Right. But their own, what was ever going on with them, prevented them from seeing. My job here is I'm not emotionally invested. I'm here to help you get to where you need to go. And sometimes you are in your own way, and I have to push you out of your own way so you can get to where you have to go for the benefit of yourself and your child. And I strongly disagree with lawyers that just simply argue for the sake of arguing, because that's just as bad. And you are just stealing these people's money because these people are passionate. They have felt like something is being taken away from them, and they will spend the farm. And it's not our job to take that money from them. It's our job to show them how to use that to the best of their ability. So the reality is when they come to me, I have a harder talk with them than any judge. And at the end, if they go through my interrogation and they still say, this is what I'm seeing, and I look at the evidence and I say, you know what, I can see the argument. I'm not saying they're right or wrong. I'm just saying that it's possible that there is an argument there that can be made and supported by the facts and the law. I will go to bat for you. Right. And I've done it for both sides. Like, it's ironic. Sometimes I go to court and I'm arguing on a Monday for the targeted parent. And then on the Tuesday, the favored parent, and the judge is like, isn't that ironic? You were just here yesterday arguing the opposite. And I said, Your Honor, those are two different people. But the reality is that when you are there, once you pass that threshold, that the client acknowledges that they're not perfect and that they can improve, but right now the urgency is taking care of this child, then we go forward. So I would suggest that for your listeners, that whoever you hire, you don't want a yes person. You want a person that's going to support your position person. And those are two different things.
So we get a lot of feedback, and even in my social media, my posts and personal experience, we find those yes people. And what it does, and for our listeners and for families going through this and true targeted parents, they invest all these dollars into this firm and into this legal team, and they end up walking away with the same that they started, nothing. And so it's really frustrating, and it creates a lack of trust in legal counsel. And so it's so refreshing to hear your perspective. I'm curious, in your territory, in Canada, because I have a lot of people who follow me and they say, oh, it's absolutely horrible. It's horrific. There's no best interest of the child. How are you seeing the courts start to embrace not necessarily the word parental alienation, but the behavior of intentionally sabotaging the relationship with one parent?
In my experience in this jurisdiction, I think the worst thing a parent can do is diagnose by saying the other side is alienating. Because once the word has kind of, it depends on which judge you're dealing with, which jurisdiction you're dealing with, and that word could either help you or sink you before you even say anything else. So I would caution by making that terminology. What I would do, and this is what I try to do with the court, is point out the conduct. Let the judge, what the judge may not call it alienation, the judge might just call it, a conflict. Whatever the judge calls it, I don't care. What we want is the result. So if the result is I want to spend more time with my child, I'm not going to come in and tell the judge the other side is alienating. What I would say is, Your Honor, it's in the best interest for this child to spend more time with my client, and here's why, ABC, and it's supported by the law, ABC. I'm not using the word. Let the judge tell me. And it's sometimes during the process of the litigation, the judge will say, "Oh, that seems to be like alienating behavior," and I'm like, "Aha, I agree with you." And if the judge says, "Oh, this doesn't seem to be alienation, but it does seem to be a parent conflict problem," and I'm like, "Aha, I agree with you." I don't care. The reality is that I want the child to spend more time with my client, and unless you can show me why, I don't want to get into an argument as to the terminology and the theory of alienation. And then the judge is pointing out every element that could be alienation and saying certain parts are missing. So now we're arguing over terminology. We're not arguing over the child spending more time with the parent. I think a lot of people get confused because they're so emotional and then they get sidetracked. And then they go through a whole litigation and then they're like, well, I never really got to say what I wanted to say, because every time there was a new position presented, we went down that path. And that path is either a day or an hour of extra trial. When it comes to the court, a lot of the courts don't have, or the judges don't have a lot of time, and a lot of them are not educated in this. So you can't also come off as an arrogant, I know it all about this, because they're just going to you're turning them off. You literally have to know your audience. All right. So you would come in, I'm hoping you know the judge or have experience with the judge. That is, I would say, huge, because you kind of know how far you can push it. The next thing you would be saying to them is, Your Honor, I'm not here to change the system. We're talking about specifically this child, these facts. And in this child, these facts, this is what's happening. And whatever you want to call it, I'm just saying that the best interest of this child, because that's what this court's here for. That's what you keep throwing down my throat. Is it the best interest of this child not to spend time with my client? And if that's what your decision is, you need to put on the record why. And that's focus. We're not talking about everything. He cheated or she cheated, or she didn't give him a Christmas card. We're not talking about that. We're talking specifically over this. Why are you preventing this child from seeing my client? And if you'll see how difficult it is once you take away all the minutia, it's a very simple answer. The judge will actually try to work with you to get that child back with the parent, because unless the child's being abused or there's some dire reason why this child shouldn't be there, it's going to happen. Now, I can tell you, I have a situation where we were successful. I represented the targeted parent, and we were successful. Proved that the other parent, the favored parent, was not acting appropriately, but the child aged out. And I say to the court, we were here 3 years ago, and you kept pushing us down and pushing us down, telling us to go for here and tell us to go for there. And now the judge literally says, you know what? I wish I could do more. We got cost, but was that the goal? The goal, remember I was saying, what's the goal? The goal was to spend more time with your child. 3 years of litigation. He received money, but he didn't get his child. So my advice is that if we start from the very beginning, and when you're dealing with an alienating situation, you have to go quickly. You can't delay, and like I said, you can't negotiate with someone who has a gun to your head. So you need to take the proactive steps to get it done. And that's what, back to when I said, when I meet the client at the beginning, it's working on all the issues that I anticipate the other side's going to point at you, and we're prepared not only for the other side but for the judge. And then we're now focused. We take that whole pointed, it's not my fault or it's the parent's fault, out of the equation, and we focus on what is the best interest for the child, and that is to spend time with both parents, unless the parent is doing something untoward, and then we argue the other way.
So, litigation abuse, you see it a lot in the alienating parent. And I'm sure in Canada, like everywhere else, the court dockets are full. I mean, I have a client who's been fighting for 3 years and they finally got a trial in April, right? So it's every every court visit is 60, 90 days, and that's 60, 90 days away from their child or children. So when you are in a high conflict divorce or separation or custody battle, and the alienating parent continues to make motions on a constant, regular basis, that itself tends to extremely delay the outcomes, because the judge is looking at this every 6 weeks and saying, well, now we got to deal with legal fee expectations. Now we got to deal with healthcare expectations. Oh, and they want access to the school. It's a strategy. How are you managing that? And are you seeing that?
Yes, I'm seeing that, unfortunately, very frequently. The problem, like, I'm going to tell you how I manage it, but I'm going to tell you that the problem right now is, as you said, the courts have their own timeline. I can't do it. I can tell you, just recently, I did an emergency for non-compliance, and it was successful because the other parent was wrongfully withholding the child, and it was after a final order. So after a final order, you don't have to go through that whole process. You just bring an emergency motion for enforcement. A lot of people don't know that. They spend time trying to negotiate. Like I said, you can't negotiate if someone is not willing to negotiate. Do that right away. So if you have a final order and there's non-compliance, do not delay. You don't have to say, oh, it's going to be 3 years for this to be heard. It will not. It will be heard quickly, because your urgent motion has to show the court the best interest is to have this dealt with right away. The child would be damaged. I treat this as an abuse. So you have to make sure that the court deems it urgent. So that's one way if it's a final order. But let's talk about at the beginning. which is, I would say, most of the times this happens. The family is there, they're great until the date of separation. And then all of a sudden, one parent or the other parent is no longer capable of taking care of this child. And that parent is the worst parent on the planet. Then they do the litigation, as we know. And in this jurisdiction, they do an application. Sometimes they try to do an emergency motion, but that doesn't usually fly. But they do an application for divorce, and they usually, they go to, if they're not married, they just do an application to have parenting rights. And then the other side has 30 days or to respond, and then another 10 days to respond. And then you have a case conference, which is usually 3 to 5 months later. So if you look at the time from the beginning of that application to the time you may have a case conference, it's maybe 5 months. So what I did, just again, another case recently, because I don't know, I have a lot of cases that deal with alienating parents, and it's not like I said, hey, come to me. It just, I think it's my personality, because again, I know both sides, so it's not like I'm someone's looking at me and saying, oh, he's one dimensional that way. He's only going to argue for that. I've argued both sides and been successful both sides. So I think that's been why, um, uh, you know, these clients have been very comfortable with me. But recently, clients came to me and said, Shawn, if I do this application, I know mother is going to remove the child, and I'll and go to another jurisdiction, go live with her parents, and I will not see this child until perhaps after the case conference date. I know that. And I said, again, tell me why. Because I remember, I just don't take what you're saying. And then he showed me previous correspondence when they were having fights, and she would threaten to take the child. She would say, I will take, there's nothing you can do. I'm the mother. I can take the child. And I said, okay, well, know what we're going to do. When we file our application, we're also going to do an urgent motion at the same time without her notice. So when we filed the application, we said, Your Honor, we are filing our divorce application, but we're also doing a without notice motion seeking that mother cannot remove the child from the jurisdiction. And we were successful. So now, believe it or not, they're still in the same house because mother's saying she's not getting divorced now because the threat of taking the child is no longer there. She would rather just stay home. But that's what she was using to coerce him or control him. And so, believe it or not, I'm now doing a motion for default because she hasn't responded. And all this, they've been living in the same house since the application, and he has seen his daughter the entire time. Now, had we not done that, I would say 10 out of 10, she gets served with that application. The next day she's gone. And now we're spending all this money trying to do motions, trying to get parenting time, trying to get her to come back to the jurisdiction, all within those 5 months before a case conference or after. So remember I said at the beginning, if you're in this situation, you have to have a plan. You can't react. You have to have a plan. And that plan worked. So my advice, so you can't, so back to the court system, the court system has their calendar. The judges have their calendar. We can't control that. The urgency is where we put the court accountable and say, well, if it's urgent, you said I can come. You need to show whatever's happening in your life is urgent. If the child is being withheld, that's urgent. If the child is being hurt, that's urgent. You just have to make sure the facts support that and then get in front of the judge. Don't wait 6, 7, 8 months when your child is being harmed. I would ask you, if you saw your child walking towards the highway, you're not going to sit there and say, you know what, by the time I run there, no, 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 you're giving her. So you're going to have to do that from the very beginning.
So, not many clients are as fortunate to have a lawyer like you. And they oftentimes will go through many lawyers
That's
before they
that's
they
you haven't
they
seen my bill yet. So let's maybe the bill.
listen, here's the thing. These alienated parents, they're paying regardless, right? And they might be paying the same fee for an unqualified lawyer versus somebody like you who's qualified. And it's not the lawyer's fault because they specialize in family law, and many lawyers will never come across a case of estrangement or alienation or resist and refuse, whatever they want to call it. And so this now targeted parent goes to a legal team. Here's what I'm dealing with. And I'm sorry, but the reality is if you're looking for work, you're gonna say, "I'll take your case." How does that targeted parent or are there any tips on quickly recognizing whether or not this is the right fit for you, and is this legal team gonna meet your needs?
Yes, yes. Here's the thing, and again, I'm just talking through my experience. But what happens? Um, the targeted parent is very emotional, right? Because the reality is, a child, a part of them is not in their life, so they'll cut off their limb to have this, rightly or wrongly. Is the the lawyer can't take advantage of that. And what happens usually, the targeted parent says, I will go to the biggest known law firm and get the craziest lawyer hourly rate because I need to defend my child. I would answer The answer to that is that's wrong. Just because you go to a law firm that has 100 lawyers are not working your file, right? So when that targeted parent goes into that law firm and you meet the big cheese, and he or she says, yes, this I've had this firm for all these years, and we have 100 lawyers, and we're known all around, we're a nation, and all that stuff. I don't care. I don't care, because with the targeted parent should say, okay, I understand that you have, an office in Calgary and you have an office in Newfoundland. I get that, but what is the office that I'm in going to do about my situation? And more importantly, which one of you 100 lawyers is dedicated to my file? Right? Because what happens is that you have one lawyer, which is like a lawyer who's older than dirt, and then you have two lawyers that just came out of law school, right? And guess what happens to the targeted parent? The two lawyers that just came out of law school are working 99% of that file, right? And then the big old dirt lawyer comes in once in time and checks off something and walks out of the room. So to the targeted parent, you have to have a relationship with the lawyer, because we're not selling cattle. We're not, selling a house. We're not selling a car. This is a part of you. Like, it's like if you go to an operation, you want to meet the doctor who's going to operate you. You don't just kind of walk in and say, oh, here's the doctor who's going to operate you. He has 30, 40 years of experience, but then these two ones that just came out of med school is going to be the one actually doing the operation. And he's going to kind of hover around and see how it's going. How do you feel? Right? You're not feeling too comfortable with that. So that happens 9 out of 10 with lawyers. It is. The reality is, as I said, you could be that in that 100 law firm, like 100 lawyer law firm, and you could be that lawyer, and you can be that lawyer who works directly with the targeted parent and work. And I say good for you, but I'm telling you, ask your audience. 9 out of 10 times they are passed on to other lawyers, not the lawyer that they went to the law firm for. They're given a lawyer from the law firm, and they say, oh, well, I know the lawyer is not the one I looked at, but there's 100 lawyers here. Those 100 lawyers are dealing with their own files. They're not even helping that lawyer. So the targeted parent has to understand, what is the mechanism of this law firm? Who's actually going to be working my financial statements? Who's actually going to be working my Form 35.1 affidavits on custody and parenting time? Who's going to be drafting my motion material? Who's going to be speaking to the judge at conferences? Because 9 out of 10, ask the targeted parents, they show up to court and it's a different lawyer who's at the conference who's supposed to know their file, and they don't know the file, and they're paying top dollars. So one of the things that I always say, I'm the only lawyer at my firm. I have a law firm that has lawyers who were lawyers in other, like I said, remember, it's the United Nations. They were lawyers in other countries. I have paralegals from other countries. I have a staff that was, from Canada. I think I have the most Canadian person. She's from Newfoundland. So what are you going to do with that? Right. So the reality is that everyone has their role here, and when the client comes, they get introduced to the whole staff, because that's the team, that's the village that is going to fight for your babies. So what I say to your audience, when they go and meet the lawyer, ask to see the village, and is this village sufficient enough for my case? Because that same money can be applied at any other law firm. You have the power. You can pick and choose who you want. Now, the lawyer might not pick you. You might be obnoxious, but the reality is that you shouldn't just accept the first one you see. because that might be, like I said, the operation, you might come out blind. Doesn't make sense to me. It's too valuable to just pick whoever they allocate to you. And you say to them too, I'm retaining you. This money is for you, not for whoever you're going to throw at court. I understand at the 100 law firm, you're going to have law clerks, you're going to have legal clerks, you're going to have all kind of staff. That's fine. But the whoever's working my file, the lawyer, you should have that intimate relationship that you know that lawyer knows your file and knows the name of your children, knows the birthday of your children, knows where they go to school, and they're not flipping through a piece of paper 10 minutes before the judge trying to figure out what your file's about.
Let's talk about experts. There's a lot of controversy internationally, globally, on the word parental alienation, and a lot of controversy on actual forensic experts in the space of parental alienation. How does your jurisdiction and your experience, how do the judges receive feedback and reports from experts? And what resources do you use if you ever needed to have an expert?
Well, I can tell you I've gone down 2 roads. I've gone down the road of having experts, and I've gone down the road with not having experts. And again, this is just my personal opinion. I know files that were expert inundated. And remember at the beginning, it really depends on the client. That's a client, like I said, the clients will spend, they'll get a second mortgage. It doesn't mean they have to. A lot of the experts are kind of just pointing to the obvious, because if you present the facts to the judge, because the judge doesn't have to call it alienation, the judge just has to call it what you're asking the judge to do. So if you can establish the facts that when the child is going over to the other, let's just say the child's going over to father's house, and father is drinking alcohol and doing drugs and doing all these kind of things that are not appropriate, I don't know why I need an expert to say to the judge that's not an appropriate environment for a child. And sometimes the experts you can get are for free, as you know. They can be from the government appointed programs, but sometimes they might have someone just out of school that's not appropriate, and that can actually hurt your case. And now you have to
Mhm.
spend more money getting an expert to contradict the expert, and then it becomes a battle of the experts. I I I can see the judges at 9 out of 10 times, they're just looking, and one expert is saying something for one side and the other expert's saying something the other side, and the judge, I don't believe, gives too much weight to it, because these are not, to me, these are not that complicated situation. Either the child is being wrongfully withheld or alienated or estranged. Those facts can be established with a qualified lawyer who can get those points out to the judge. And there's case law that the judge can rely on without having the battle of the experts. Experts are expensive. So I would have to say, um, experts add to time of trial, they add time to litigation. I don't know. I think it'll be very fact specific when they're needed. I don't. I think obviously experts get paid when they have to come to court. So and they're usually saying exactly what you're saying. They're not contradicting you. So are you just paying to have the same voice? Why can't we say that? Why can't we save that money and present it in a different way? That's my approach. I don't usually have experts. I say to the judge, you have the authority. The case law confirms you do not need an expert to call this what it is. So, and I never had a judge say, "Oh, you know what, Mr. Philbert, I wish you had brought an expert to tell me that by this child being beaten up, that now all of a sudden this is alienation." Like I don't see the math. Again, I don't have a lot of relationships with experts. So if you ask if your audience is asking the lawyer, like, why are you suggesting this expert? And it turns out that this expert and the lawyer have worked every file together. Then is this really about I need an expert, or is this really about, we're feeding each other? And I'm not going to make any friends here from I'm giving all the secrets, but the reality is that we have an obligation to do the right thing here. So back to your question, yes, experts are used. Mm, Most of the time, those cases go for trials are like multiple days, weeks trials. I pride myself in having short trials. I pride myself of doing the work. So on the time of the application to the time of the trial, you should have most of the work done. And the trial should just be honing in on the very stuff that cannot be, has not been established already. Prior to trial, you can do what they call examinations, right? So if you can get the other side to admit in their own words all of the criteria, why do I need an expert? Right? The other side has used their words. Prior to trial, they can do what you call request to admit, where these are facts. Did you not withhold on this day? Did you not threaten this on this day? Why do those are their own words? We could do a request for information. So we can get all that information. So why do I need an expert to say exactly what the other side has used their own words for? There are different strategies you can use to avoid that extra cost. When you do need an expert, it has to be fact specific. Why? And I would ask your audience, when the lawyer says we need an expert, number one question is why? How will this add to my case? How does this benefit my case? What can we use instead of the expert that has already been established? Right, and then and I would say that would be more beneficial to at least to my files. And I think beneficial to the court. Shorter trials, more efficient trials, trials that the judge can say, okay, this is organized, are more successful trials for everybody.
So, a really big increased, or maybe just it feels like it's increased false allegations of physical or sexual abuse. Are you seeing more of that or does it seem consistent? Thoughts on that?
Oh, you know, you had to poke me. Like I got like little chills going through. This is personal. It's
Yeah.
wrong, man. You know, it's simply wrong because because you're going into a very contentious battle and then you bring up, and this is happening so frequently, these allegations, historic allegations of abuse in order to get a leg up in the litigation. And it's wrong when the police say, you know what, once we get that, we have to, they don't even investigate. So I represent lots of, and it usually works one way. Lots of males that have been accused of assaulting the child or the other spouse, and then that's the reason why that they can't have interaction with the child. So again, it's a they're using the legal system to get a leg up on getting withholding the child. And one of the so what do I do? And I say to the client, especially they call and they say, you know what, Shawn, I'm thinking about leaving my partner, but I'm worried that I'm not going to see my child, right? And it shouldn't be that. It should be I'm leaving my partner. We have a parenting schedule in place. We're good. But it turns into, if you leave me, you also have to give up your child or your children, and that's so wrong. So what I would say to that person, I said, okay, here's the situation. Do not be left alone in the room. Make sure there, if you have some kind of device, to make sure that um, they can't make a claim against you. And they said yes, but here's the problem with that. Now they are claiming something that happened 2 or 3 years ago, right? So now I get a call and they're like, you know what, I've been arrested. They said 3 years ago I had sexually assaulted, and now I can't see the other side. I'm prevented from going home, and I have no place to stay, so I can't have my child. That's the problem, and now you have easily months of the criminal side preventing you from seeing your child, combined now with a family side. So my advice in those situations is that, again, do not wait. You get arrested on the Tuesday, you are in family court on the Wednesday. You are whatever charge. Hopefully, it's not a charge against the child, inappropriate child, but if it's a charge against the spouse, there's no reason why, and especially a historic one, there's no reason why that child shouldn't be spending time with the other parent. You just have to now create a great parenting plan to ensure that you are able to take care of that child. You can't be a truck driver at 28 days out of the month on the road and fighting for 50%. You have to have a plan, right? So you get arrested, get on that phone with your lawyer, get to that family court, have that parenting plan in place because you do not want a delay. Because what has happened, you have a delay of, I don't know, 2 or 3 months, and now you're in front of the court. And then know what the judge says? Let's do a kind of a transitional thing. You haven't seen the child for 3 months. The child is apparently afraid of you because that's what the other side's saying. Let's have the child see you for 1 hour every 3 weeks. And then I'm like, what are you talking about? Before these allegations, that child was with me 50% or more. How do I go to 50% or more to 3 months now later to 1 hour a week? No, you cannot accept that. You can't. And so when you're going with your lawyer now, you're going with the premise of this is what I want. Remember, I said it doesn't have to be titles. It just has to be what I want. What I want is 50% of the time. How am I going to do it? Is here's my parenting plan, and my parenting plan is in the best interest of the child, right? But most people just rush to the court and they start pointing the finger, saying, "Hey, that person wrongfully accused me, and that person is trying to, alienate me," and we're not getting to where we need to go. And the judge has maybe 40 minutes, maybe has read your file. You want to make it as easy as possible for the judge to say, yeah, I agree. Father or mother should have that child 50%. I'm not here to determine what's happening with the criminal matter, but I don't see any harm to the child. There's no reason why father or mother shouldn't see that child during the time of the criminal proceeding. Another thing, though, a lot of the people do this criminal proceeding and then they say, okay, I can do a criminal proceeding and that I don't have to be held accountable in the family court. I make sure that if you make those claims and that's the reason why you have a leg up, I'm asking you those claims in the family court, and you can't sit there and say, "Oh, that's privilege. That's before a court." No, you brought it. You brought it into the court, and a lot you could see the surprise on their faces when I'm like, "Well, tell me about these allegations of abuse. Tell me about these charges." And they're like, "I don't want to talk about it." And I'm like, "You have to talk about it because you brought it in, and that's the grounds that you're trying to prevent my client from seeing the child. So you don't get to get a leg up, and then go silent." So it's frustrating. I could tell you because you know what else is a problem? The parent who is charged has to pay two retainers, and the criminal retainer is not a joke. So if you are, and I don't understand how the courts don't see that pressure, that hardship. And then in the family side, if you can't do something because you don't have money because you just paid your criminal lawyer $80,000, it somehow it's like you're not doing what you need to do for the family file, but you're ignoring that the only reason we're in a criminal file, which is innocent until proven guilty, is because of these allegations. So it is hard for these parents. I see it in their parent in these individuals, and I I don't have an answer because we can't. All I can say is do not give up on the criminal side, because when you now say, okay, I'm going to plead guilty, even though you didn't do it, that now affects you in a family file, right? There's a thing there, you can call what they call, uh, you go on, you don't plead guilty. You don't, have a criminal charge. You just, you know, it escapes my mind right now, but it's a term where you basically say, I didn't do anything, but I'm going to just go to take anger management courses. And then the courts will say, well, why did he need to take anger management courses? Right? I would hope the court would say, well, the reason that's logical. He was never found guilty. He was never found. He never admitted to the guilt, and he basically accepted uh, a therapy treatment in order to avoid continuing with the criminal file. To me, that seems logical. But there is an inference that, well, why did he? If it wasn't true, why did he go through? Believe that or not, I've been in front of courts where the person has been found innocent of these charges, and then um, um, in the family case, the judges says, well, you know what? It's a different degree of responsibility. It's a different degree in the criminal case than it is here. So it's a higher in criminal, but even though they didn't find the person guilty in the criminal, it's a lower standard in the civil. So I still think they did it. What the heck? What is the person supposed to do? Right? I don't know what they're supposed to do. Right? So um, the criminal side and the family side has to be fixed. There's an inherent problem with that. We can't. Right now, the system pretends that they're mutually exclusive, but they're not. They are being used together to affect the family file. Because at the end of the day, when these individuals make these claims and it's proven false, you notice they're never charged with making a false claim because they say, "Oh, we don't want to discourage," right? But what happens to that person who just spent 100 grand defending and now is in the court still defending these charges, even though they're found innocent? Where's the fairness there? And that's what I struggle with. That's probably my most passionate side. When I said I'm not emotional earlier, I get emotional about that because that is inherently wrong and should not be allowed and should not be condoned. And if it's found that you have misused that, there should be strict consequences. There are none that exist now, and because none exists, it's used with impunity, right? So I'm sorry for that rant.
Shawn, that was great. We appreciate it. I really, I think you made some really great points. As we close out, any final thoughts for our listeners?
As it relates to litigation, um, my thought is this: most time, the alienating parent is going to is you like you've been fighting for years to get to the point of just before trial, and then all of a sudden, the alienating parent says they see the light and they, oh, I see the importance of you in the child's life, and I will work together with you. All of a sudden, just before trial starting on the next day, and they see it. You got to ask yourself, why now? Why now? Because now you're going to be a day from now, you're in trial and you're going to be exposed, right? So what does the alienating parent do? They say, we'll work with you. We'll work with a parenting coordinator. They have no intention to work with that. If your audience accepts that, they're going to be in litigation again, and that child's going to be aged out by the time the second time comes around. That's happened many times. So what I've done, what I'm trying to do, is create, and this is where I was at the last conference, um, do a new agreement for the parenting coordinator that will deter an alienating parent. So if that parent signs that agreement, then you don't have to worry about going back to court again because we've addressed it. We've addressed the cost consequences. We addressed the urgency that we can bring a motion without having to go through the process. We've addressed that you can't be appealing frivolously and just adding on to you've signed off on that with independent legal counsel, and that's a contract that will be enforced if you're breached. And I think so. What I would suggest, um, my tip is it's sometimes it's cheaper just to do the trial. I know that's terrible. I know a lot of judges are going to say trials are expensive, but that's not, those are not dealing with alienating parents, right? So you're always in trial. You're always in litigation when the other side is doing things to harm a child and the relationship with you. So what I would suggest is that if you're going to do a parenting coordinator, try to see if you can use the template that I'm put together, because that is to address that, to deter that. And I'm trying to get that published right now so I can give it out as much as possible to everyone who needs it. Because at the end of the day, they have two choices: they go to trial or the matter is done. But it's not pretend the matter is done and then we're going to trial 3 years later. We're not doing that. We've seen behind the curtain. It has to stop. So my tip is make sure you get it addressed at trial or before, but there's no more pretending. We've seen too much.
Shawn, thank you so much. I'll make sure and share your contact information and for my listeners that might need your support. And thank you for being a guest on the Fractured Families podcast.
Thank you.
Thank you for joining me on this episode of the Fractured Families podcast. I hope our conversation has provided you with support, understanding, and actionable insights to help you navigate your own family challenges. Remember, healing is a journey, and reaching out for help is a sign of strength. You're not alone. If you found value in today's episode, please subscribe, rate, and leave a review. Your support helps us reach more families in need. You can contact me on social media at Parental Alienation is Real and visit our website for additional resources and ways to get involved. Stay strong, stay connected, and keep fighting for the family bonds that matter most. Until next time, take care and stay resilient.